Good morning and welcome to Leavitt's webinar on using the Lookback measurement method. My name is Lisa Klinger. I'm the benefits attorney at the Leavitt Group, and today is Wednesday, May 11th, 2016. As the initial announcement told you, all attendees are in listen-only mode. If you want to ask a question, just type it in the box that's probably on the right-hand side of your screen, unless you've moved it, and I will try to check for questions every so often, and then again at the end of the presentation. Today's webinar is being recorded, and you can listen to it later if you're a real glutton for punishment. If you don't already have a copy of today's PowerPoint and you want one, please request a copy from your Leavitt advisor, the one who sent you the invitation to the webinar, and I know they'll want to follow up with you on it. We do not have SHRM credit available for this webinar. We usually do for webinars, but last year when I did this topic, SHRM questioned whether it fit into one of their competency blocks. It really is IRS rules, not ERISA rules, so I think that might be the issue. And we do offer a number of client webinars on different topics, usually once a month or once every 2 months in the summertime, but we will be offering another one in June. I don't yet know the date, but we'll send out an announcement for it. They usually are on Wednesday or Thursday mornings at 10 o'clock Pacific time. So let's get started with this. This is a detailed webinar, and it's for large employers, which are employers with at least 50 full-time employees and full-time equivalents. It assumes that you know about the employer shared responsibility and the look-back measurement method, and that you're using the measurement method, and you have some questions about how it applies in certain situations. So I'll do an overview of some things, like the 4 steps to compliance with the employer mandate, some of the penalties for not complying, seasonal employees and variable hour employees, and an overview of the look-back measurement method itself. And then I will apply it to various examples and questions that we've had from clients, and then looking at some specific nuances and requirements under the law on counting hours if there's a break in service, and also how it works when there's a change in employment status. So, and again, if you're just joining us a few minutes late, we just started. I'm on page 3 of the slides, and the webinar is being recorded, and the PowerPoint is available from your Leavitt advisor who invited you. So if you didn't already get it, please contact them afterwards. And for those of you who are at Leavitt, it's posted on our intranet, and I sent an email link yesterday. So first, you probably recognize this from the Leavitt 4 steps flowchart and the documentation. The 4 steps to compliance with the employer mandate are determine employer size, determine the compliance date, determine what will be offered, and determine which employees will be offered coverage and when. And the look-back measurement method is a part of the 4th step, determining which employees will be offered coverage and when they'll be offered coverage. So another quick overview, what do you need to determine in using the look-back measurement method? And then we're going to talk about how you determine those things. The first is, as of what date does or did the employer mandate apply to you? And to which categories of employees will you apply the look-back measurement method? For example, hourly or salaried employees, or all employees. And for many employers, it makes the most sense to just apply that, to have that be your default method. The third thing is you need to set your standard periods, the stability period, the administrative period, and the measurement period. And then you'll use payroll records to track the hours of ongoing employees during the measurement period. And the next thing is you'll need to look at which particular employees will be tracked using the most recent look-back measurement period. And for example, you'll need to know who's a seasonal employee and who's a variable hour employee and who's a regular full-time employee, because that affects whether you use the look-back measurement method. And then you'll need to also set your initial periods, the stability and administrative and measurement periods, and you'll need to track new hires' hours in both the initial measurement period and the standard measurement period. And then we'll look at also if a new hire changes from part-time to full-time, what do you do? Do the waiting period rules apply and require an earlier offer? And what policy will you apply for breaks in service? So, kind of a general question, why do employers need a measurement method? Well, obviously, you know, the reason for the measurement method is so a large employer can determine which employees are full-time and when they became full-time. And that determines when they're eligible for coverage and when you need to count them in the calculation of the penalty amount. Because for an applicable large employer, you may be subject to penalties if you don't offer minimum essential coverage to at least 95% of your full-time employees. Or if you do offer minimum essential coverage, but it's not minimum value or affordable, then if an employee goes to the exchange and gets a subsidy, you will be subject to a penalty. So that's why it matters. That's why you need the measurement method. And then in calculating which employees are full-time, there are two different measurement methods. One is the monthly measurement method, and the other is the look-back measurement method. And the reason you're using those is to determine if particular employees worked at least 30 hours a week or 130 a month, because if they did, then they're full-time and they count in your employer shared responsibility compliance. To digress for just a minute, kind of a quick review of the penalties. And the measurement methods help you avoid having the penalties applied. So there are two penalties, the 4980HA penalty, often called the sledgehammer penalty, and then the B penalty, often called the tack hammer penalty. And I'm sure you're familiar with these, but as we go through, as we go through the slides, keep these in mind. The A penalty is if the employer does not offer coverage to at least 95% of all full-time employees in 2016. And the penalty calculation for 2016, and it was originally the $2,000 penalty. Now it's the $2,160 penalty per year, and that applies per each full-time employee minus the first 30. And that even includes employees who are enrolled in or who you offered coverage to your group health plan. And then the B penalty, the tack hammer penalty, is even if you do offer coverage, minimum essential coverage, to at least 95% of full-time employees, if for any particular full-time employee the coverage is not affordable or doesn't meet minimum value, then the penalty is $3,240 per year times for each employee full-time employee who goes to the exchange and gets the subsidy. And that was originally the $3,000 penalty. And for that B penalty, there's no 30-employee offset. So, and those amounts are calculated monthly and then applied, and then each month is added up. And again, the penalty is only imposed if at least one full-time employee goes to the exchange and gets a subsidy to buy coverage in the exchange. So the next issue is which measurement method to use, the monthly measurement method or the look-back measurement method? Well, one of the considerations to keep in mind is that you have to use either the look-back or the measurement method or the monthly measurement method for all employees who are in the same category. And the regulations specify 4 allowable categories. So that's salaried versus hourly employees, or collectively bargained versus non-collectively bargained, or each group of collectively bargained employees, if you bargain with different groups, or if you have employees in different states, different primary places of employment, you can have a different rule in each state. So you couldn't just say, we're going to apply the look-back rule for people who work part-time or variable hour or seasonal, and we're going to apply the monthly rule for people who work full-time, unless that also happens to fit into your salary versus hourly category. And you may just want to have the look-back measurement method as your method for all employees. One question I've had regarding this is, what about different entities in a control group? Could different entities apply different measurement methods? And the answer is yes, you can use different measurement methods. Each entity in the control group could. So for example, if Company A and Company B are in the same control group, Company A could use the look-back measurement method for all employees, and Company B could use the look-back measurement method only for hourly employees. There is, of course, an exception to this general rule about using the same measurement method for all employees in the same category. And this exception is a really important exception. The exception is for a newly hired full-time employee who's reasonably expected at the date of hire to work full-time. The employer has to track the hours of service each calendar month and then offer coverage by the first day of the 4th calendar month to avoid the 4980H penalty. Now there's also the waiting period rules under the Affordable Care Act. And so most employers actually offer coverage within 90 days because the waiting period rule, which is under Public Health Service Act Section 2708, says that the coverage has to be offered by, the waiting period can't be any longer than 90 days. 90 calendar days. So, and I've got another slide in a little while about the waiting period versus the measurement method period. But and many employers also have a shorter waiting period. So even with the exception, if you have a newly hired employee who's reasonably expected to work full-time, you have to track their hours on a monthly basis, even if they're in a category to whom the look-back measurement method generally applies. And you have to keep tracking their hours monthly until they become an ongoing employee. And then once they're an ongoing employee, you track them under the method that applies to that category. An employee doesn't become an ongoing employee until they've completed one standard measurement period. So we're going to talk about those things as we go through the slides. Here's a graphic that might help. Some people, it helps to look at a picture rather than read some words. So the measurement methods, for example, where the employer selects the look-back measurement method for all categories of employees. However, here's the exception, and here's the standard look-back measurement method. If you have a newly hired employee who's reasonably expected to be full-time, then first you track their hours monthly, even though the look-back method applies. And then after that cycle, then they go down to the gray box at the bottom. If you have a newly hired employee who's not expected to be full-time, the middle of the slide on page 9, then you track them from the beginning in an initial look-back measurement method. And then with an ongoing employee, you're always tracking them at a standard look-back measurement method. And now again, this is if the employer selects the look-back measurement method for all categories of employees. Otherwise, this would only apply for the categories to whom the employer does apply the look-back measurement method. So, the look-back method was developed to track hours for variable hour employees. Because initially in the law there was just the monthly measurement method, and employers said, well, what about all these employees who we have who sometimes work part-time and sometimes work full-time? So even for a new variable hour employee who it turns out works full-time, you can still track their hours from the date of hire using the look-back measurement method. And also the regs allow the look-back measurement method for newly hired seasonal employees, even if they're reasonably expected to work full-time. But if they're seasonal employees, either newly hired or ongoing, even though they work full-time, you can use the look-back measurement method rather than the monthly measurement method. But it's not okay to use the look-back method to track hours of newly hired non-seasonal employees and non-variable hours who are expected to work full-time. And so sometimes there's a confusion for an employer about whether a new hire is reasonably expected to work full-time or is a seasonal employee or a regular employee or a temporary employee. So I'll just to kind of try to help clarify that. because it makes a big difference for employers. If you misclassify someone as a seasonal employee or a variable hour employee and they're really not, then you should have been offering them coverage much earlier than you would end up offering them coverage. So the regulations say a seasonal employee is one who's hired into a position for which the customary annual employment is 6 months or less. And customary means that they typically work each year about the same time, like they work during the summer, or they work during the winter, or they work at the Christmas season. And again, if it's truly a seasonal employee, even though you hire them to work full-time, you can apply the look-back measurement method. And a variable hour employee, as I said, is one who at the date of hire cannot reasonably determine whether they're going to work full-time or part-time. And so then you can apply the look-back measurement period, and the look-back measurement period applies instead of the waiting period. And here's some examples of seasonal employees. If a city hires lifeguards to work each summer at the beach or at the public pools, and they work for 4 months, that's a seasonal employee. Or, and the regs give the example of a ski resort that hires instructors to work each year, say from October through March, so it's for 6 months. Or a farm hires pickers each year, July to November, to pick vegetables and fruits, and that's 5 months. And the regulations also say that if in a particular year a person was hired as a seasonal employee, but then the season extends beyond the usual duration, they can still be considered a seasonal employee. And the preamble to the regs gives the example of a ski instructor who's usually hired for 6 months, but there's a lot of snow that winter, so it goes to 7 months. So that the person would still be considered a seasonal employee. Now, some examples of non-seasonal employees, and this is where sometimes employers have some confusion, is if the employer says, oh, these are seasonal employees. We hire them to be, we consider them seasonal employees, but the season is 7 or 8 months. That's not a seasonal employee. That's really a regular full-time employee, and you would need to offer that person coverage by probably by the 90th day after they're hired, if they're hired to be full-time. So just the employer classification of someone as a seasonal employee doesn't make them a seasonal employee for these purposes. But of course, there are a number of categories that are sort of ambiguous. And one of them is, what if you hire an employee to work the summer season and then also hire that person to work the winter season? So it's 2 different seasons, it's 2 different jobs, but it's the same person. Or an employer hires students as full-time summer interns, and then they also hire them, some of them or all of them, part-time during the rest of the year. And I have some other slides later on that kind of go through that. But there's not a definitive answer for those. Another category is temporary full-time employees. And this is really an employer term. Like, you might be hiring someone for a particular project of a certain duration, and maybe it's 3 months or 5 months or 6 months, and you're hiring them to work full-time, and you think, well, this is really a seasonal employee. But they're not unless it meets the definition of seasonal employee. So the definitions and the categories under the regulations are seasonal, variable hour, part-time, and full-time. So even if your payroll system has a category of temporary, that's not a different category under the regs. It needs to fit into one of those categories under the Affordable Care Act regs. And if you hire a temporary employee who's reasonably expected at date of hire to work full-time, even if it's only for 5 months, if they're not a seasonal employee, you cannot apply the look-back measurement method to them when they're first hired. You need to offer them coverage by the first day of the 4th month. So this is just to summarize, when can the look-back measurement method apply? So the times when it cannot apply, we'll say that, are to someone who's newly hired and reasonably expected at the date of hire to be full-time, even if they're a newly hired temporary employee. And then it can apply in the other situations. So we finally get to the look-back measurement method itself. There's, of course, a measurement period, an administrative period, and a stability period. You track hours in the measurement period. You calculate who's worked enough hours and offer benefits in the administrative period, and then in the stability period, you offer coverage. And how it really works is that you probably set the stability period first, and that starts on the same day that your plan year starts. And if you have a 12-month stability period, then it's the 12 months of your plan year, and you work backward from there. So, again, starting at the stability period, it usually starts on the first day of your plan year. The stability period has to be at least as long as the measurement period, and it has to be a minimum of 6 months. And during the stability period, you're offering coverage to employees who were full-time in the measurement period, regardless of how many hours they worked during the stability period. It's like the old hour bank method. So that question comes up a lot. What if somebody was full-time and now they changed to part-time? And again, that's the point of the stability period, is that people who were full-time during the measurement period continue to be considered full-time during the entire associated stability period. And during the measurement period, you track employees' hours. And those thresholds are, if you have a 6-month measurement period, an employee who has at least 780 hours of service during the 6 months is considered to be full-time. And if you have a 12-month measurement period, then an employee who worked 1,560 hours in the 12 months is full-time. So the regs say if the employee worked an average of 130 hours a month over the measurement period. But when you're actually counting it, that's what the average is. If they meet the 780 threshold or the 1,560 threshold, then they're full-time for that measurement period. And the administrative period, again, during that, you calculate who was full-time, you add up the hours, divide by 6 or 12. You notify the employees who were full-time that they're full-time and eligible for benefits, and give them the enrollment materials and give them the time to enroll in coverage. And here's looking at how this applies over 4 years, the measurement, administrative, and stability period. And I just want to point out, I'm sure everyone's familiar with this at this point, but as soon as one measurement period ends, the next one begins. And as soon as that ends, the next one begins, even though I seem to have a little gap right there. So remember this later when we're talking about changes in employment status, that if someone has a change in status when they're in their measurement period, they're also concurrently in an administrative period, and they're concurrently in a stability period. So you'll see on later slides when we talk about when there's a change in employment and where in the cycle a person is. So here's some questions we've had so far. 1, during the measurement period, must I count all hours an employee works, or can I cap it at 40 hours? The answer is no, you cannot cap it. You must count all hours worked. Plus, you have to count hours of service, even if they're for which an employee is entitled to pay, even if they're not working. So then another question was, do I have to count hours an employee is on leave or vacation? So it's not just hours worked, it's hours of service. And it also includes special unpaid leave, which would be FMLA and jury duty and military leave. And another question that's come up is, what about if someone's on leave, if they're on disability, if they're getting disability benefits? If they're on insured disability benefits, and if the employer paid the premiums, then you do have to count those hours as hours of service. But if the employee paid the premiums with after-tax dollars, then the time that an employee is receiving disability benefits, those hours of service do not count when you're counting the hours of service under the look-back or the measurement method. Another question is, can I count hours per pay period rather than per calendar month? And the answer is yes, and whether you're using the look-back method or the monthly method, there's some weekly rule. under the look-back method, you can use a 1-week, a 2-week, or a semi-monthly payroll period. And either you're going to exclude January 1st and include December 31st, or vice versa. And if you're using the monthly method, then there's a weekly rule where you count some months as 4 weeks and others as 5 weeks. And then the 4 weeks, you're looking at 120 hours as the threshold, and the 5 weeks, 150 hours is the threshold to be full-time. And your payroll service or your payroll software, I'm sure, has that built into it, so you can count that way rather than on calendar months. Some other questions.
You have another question waiting for you.
Okay, thank you, Jessica. I'll take a look at that. Let me switch over for a sec. How do you treat someone who's hired part-time in a measurement period and then goes to full-time? Okay, well, actually I'm going to get to that, but I suppose as a general answer, when someone's hired part-time and they're still in their initial measurement period and then they go to full-time, as of the date they go to full-time, you need to start treating them as a full-time employee, and either offer coverage as of the first day of the 4th month after that, or if it's sooner, then if it's near the end of their measurement period and the first day of their stability period would be sooner than for the 4th month, then you have to do it at that time. And the reality is the waiting period rule applies, so it's probably within 90 days after the person changes. And actually in practice, most employers would, whatever waiting period they have, which maybe it's 60 days rather than 90 days, they would probably apply that to the person. And I have a slide in a while that shows that, so I'll go through that. Another question is, we have college students working 25 hours or less, but would work 40 hours during school breaks and possibly during the summer. Would they be eligible to receive benefits, and should we just not offer 40 hours a week when school is out? Well, if you can hold that question, I have 2 slides that specifically deal with that. So there's not a definitive answer, but I have a slide that deals with the 2 ways that you might handle that. Okay, some more frequent questions. Here's one I get a lot. Must I offer benefits to an employee for the rest of the stability period if the employee's hours drop and he or she works only part-time? And again, to reiterate, yes, in most cases you do. There's a limited exception, which I'll discuss later. But that's the point of the stability period. If the person was full-time during the measurement period and now they're in their stability period, even if their hours drop to part-time, you need to consider them full-time. So technically, let me just step back a minute here. The employer isn't required to offer benefits, but what they're required to do is count that employee as full-time. And even though we call it the employer mandate, it's really employer shared responsibility. So the employer mandate doesn't mandate that you provide benefits, but what it says is if you don't offer benefits to at least 95% of full-time employees, then you're subject to these potential penalties that only apply if somebody goes to the exchange and gets a subsidy. But we often say, okay, if an employee is full-time in the measurement period, then you have to offer them benefits in the stability period. Actually, you wouldn't have to. You could take your chances on whether a penalty would apply. For example, if you don't offer benefits, the B penalty, that tack hammer penalty, if that particular employee buys coverage in the exchange and gets a subsidy, then you'll have that B penalty, the $3,240 a year for that employee. And if more than 5% of your employees are in that category, then you could be subject to the A penalty, the sledgehammer penalty. So the practical result is most employers do offer benefits to all full-time employees, and I will often say that in the presentation. But technically, if you felt like, okay, there's 1% of my employees who, even if they're full-time, I don't want to offer them coverage. You can't list them by name. It would have to be a particular category. Then you could not offer them coverage. You wouldn't be subject to the A penalty if it's only 1 or 2%, or even up to 5%, but you would be subject to the B penalty if any of those particular employees that you didn't offer coverage to went to the exchange and got a subsidy. And another question along that same line is, do I have to continue to pay for benefits for such an employee? The employee who was part-time, who was full-time in their measurement period, now they're in their stability period, and now they go part-time. Well, the answer is no, you don't have to, but you probably will want to continue to, because the Affordable Care Act itself doesn't require employers to pay any particular amount or to pay the same amount for all employees, but other rules will come into play. And for one thing, the carrier is going to have minimum contribution rules. So if the carrier rule says the employer has to pay at least 50% of employee-only coverage for all eligible employees, then the employer could not say, okay, well, for people who were full-time and now they're part-time, I'm going to pay 0 or 25%, because those employees are considered full-time if they worked full-time in the measurement period. Also, your SPD and your other employer communications probably say that you're going to pay at least X percent, say it's 70 or 75 or 80% of the cost of employee-only coverage for all eligible employees, all full-time employees. So if you're not going to do that, you're going to have to change what your employee communications and your SPD. And the third thing is the affordability test applies. So it can't cost a full-time employee, or if it costs a full-time employee more than 9.5% for the for their share of the employee-only coverage, then that person can go to the exchange and the employer will have a penalty if that person gets a subsidy. So those people are full-time employees, and as you probably are well aware from doing your recent information reporting, you know, that would end up showing up on the information reporting. So that's why you may want to continue paying the same. So enough of the questions for right now. We'll go back to the look-back method. Again, there are the two kinds of measurement methods, the look-back measurement method and the monthly measurement method. And then just looking at the look-back measurement method, there are two kinds of look-back. There are two phases of it, or two kinds of look-back methods. There's the standard method and the initial method. And the standard method applies for ongoing employees, and the initial method applies for newly hired employees. So an ongoing employee, as I mentioned before, has worked through one full standard measurement period, and they were hired before the employer's first standard measurement period. And so the standard look-back method applies to them. The initial look-back method applies for newly hired employees. So, and it's newly hired employees who at the time of hire are not expected to work full-time. So that would be your variable hour employees. And to newly hired employees who meet the definition of a seasonal employee. But it doesn't apply to a newly, as I told you, there's an exception for the newly hired employees who are reasonably expected at the date of hire to work full-time. So even if they're in the category, you track their hours monthly. And even for a new hire, the initial look-back method only applies once, because once they've been there for one standard measurement period, then they're an ongoing employee, and then that you stop using the initial method and you only apply the standard measurement method to them. Now there is some confusion, as I have in red, about the initial standard measurement period, and it's not the same as the initial measurement period. So here's a picture. Sometimes a graphical way helps some people. It's a good way to depict it. So here we've got the 12-month standard measurement period, and the example I gave before, where the employer has a plan year of January to December, so they have a standard stability period of January to December. Here I'm using just a 1-month administrative period, just the month of December, but an employer might use a 2 or 3-month administrative period. It just fits on my calendar better if I just use 1 month. And then there's a 12-month standard measurement period. So that's from December 1st, in this case of 2015, through November 30th of 2016. Then the administrative period is the month of December 2016, and then the standard measurement period is the calendar year 2017. And as soon as then the next standard measurement period starts December 1st, 2016. But say an employee is hired excuse me, in May of 2016. So or hired June 1st. Their 12-month initial measurement period starts June 1st, and it runs until May 31st of the following year. So for the initial measurement period, an employer would track the employee's hours. Then they would also track the employee's hours for the first standard measurement period that begins after the employee's date of hire. So that would be December 1st, 2016. And I've got a blue bar at that point. And I'm on slide 23, just for people who might be listening to it later. And the other thing I want to mention is both the standard and the initial look-back measurement periods and methods are applying simultaneously. So the standard look-back measurement method is always going on, and then when an employee is hired, the initial look-back measurement method comes into play. And so again, you're selecting the start date, then you're tracking hours, you're tracking the employee's hours of service in that date. Then at the administrative period, you're doing the math to see who is eligible. And then for people who were full-time, you're offering coverage, and then you repeat that process again. And that's the standard look-back measurement method. And then in the initial one, you're tracking that you don't repeat it. You only do it once, but you're tracking in the overlap period of when the person was in both the initial measurement period and the standard measurement period. So that would be the point between the blue bar and the maroon bar. And your payroll system will be doing this. You're not doing some separate tracking. You just need to generate the right reports from your payroll software. So it's tracking the payroll hours or the hours of service, even if not paid, during those periods of time, and you will just be printing a report for whichever periods of time you want it, for probably each month. And then for the standard measurement period and for the initial measurement period for newly hired. So again, even though I've just said it, I still get the questions, what do you mean the initial standard measurement period is not the same as the initial measurement period? And I'll show you again on the next slide. And another question is, wouldn't I want to use a 6-month measurement period if my variable hours mostly work for only 6 months of the year? So again, I'm back to this slide for the first question. That the initial, and I've kind of added this down at the bottom, here's the new hire's initial measurement period, and here's the new hire's first standard measurement period. So we're probably better off to call it the first standard measurement period rather than the employer's initial measurement period. And this slide addresses the second question about the 6 months versus 12 months. Even if your variable hour employees usually just work for 6 months, you don't just track for 6 months and then not track for the next 6 months. So as soon as one measurement period ends, the next one starts. So you're still measuring everyone every 6 months. And assuming you have if you have a 12-month plan year, if you're using a 6-month measurement period, then you've got people potentially entering your plan twice a year, which isn't the end of the world. But then you have, if you set up your measurement periods at these particular dates, you've got the 6-month stability period starting January 1st and another 6-month stability period starting July 1st. You might have some people who are full-time in this measurement period, so they're eligible for coverage, and then they're not full-time in this measurement period, so then they drop out of coverage, and then they might be full-time in this measurement period, and then they're going back into coverage, which maybe is what you want. The other, but that might be more administrative burden than you want. The other thing is mathematically, you'll have fewer employees who qualify as full-time if you use a 12-month measurement period, but those who do qualify will be considered full-time for 12 months rather than only 6. On the other hand, the 6-month measurement period means that more employees will qualify as full-time, but they'll only have to be offered coverage for 6 months. But it means you've got an administrative period every 6 months, and you've got to do the tracking and notify the eligible employees and get them the information, and then people are enrolling or disenrolling if they're not eligible. And if they're not eligible, then you're offering them COBRA because they bid on your plan.
Lisa, you have another question waiting.
Okay, thank you. I'll take a look at that one. If someone is in their measurement period and has a status change to full-time, they did not average 30 hours during the measurement period, but the employer allows it full-time on benefits. In the stability period, the employee has another status change back to part-time. Do you have to continue the medical for 3 months and measure them on a monthly basis? You know what? Let me come back to this one once I go through some of those rules. And I'll speed up through these rules. So you're setting the standard periods. Again, I talked about these. It's probably the 12 months for the 12 months. The stability period is probably the plan year. And here's an example of different stability and measurement periods if you have a plan year starting January 1st, April 1st, July 1st, and October 1st. So that's just something to keep in mind. And here's just a matrix that shows the same thing that I just showed on the last slide. And then you're going to set your initial periods, and it can be, it's basically the same as setting your standard ones, except your measurement period begins on the date that the employee is hired. Or you can do it as of the first day of the next month. For example, someone's hired August 13th, the measurement period can start August 13th or September 1st. And one other thing, a difference between the initial and the standard measurement periods, the stability period generally is the same length as the standard stability period and the same length as the initial measurement period. But for employees who are not full-time in their initial measurement period, the initial stability period can be 1 month longer than the initial measurement period. And I think that some of you probably had, and that's only for new hires, some of the payroll providers were using that initially so that they were having employers, their system defaulted to an 11-month initial measurement period and then a 12-month initial stability period. So some of you may have already had that. The other thing I want to mention is that affects your initial administrative and measurement periods, the length of them. There is a limit on the length of how long the initial measurement and administrative period can be. And that's 13 months and a fraction of a month. So it can't extend beyond the last day of the first calendar month beginning on or after the 1-year anniversary of the employee's start date. So for example, an employee who's, well, I better go back. An employee who's hired February 13th to 29th of 2016, that's their administrative period. March 1st, the measurement period, the maximum will be March 1st, 2016 to February 28th, 2017. Then there's the second part of their administrative period, and the stability period has to start no later than April 1st, 2017 for an employee who was hired by, say, in February of 2016. And this slide just shows, again, that maximum length of the initial measurement and administrative period, and depending on how long your administrative period is, so the initial measurement period could be 12 months or 11 months or 10 months, but this total time is the same. It just depends on how you divide it up within that 13 months and a fraction of a month. Let me just mention about the waiting period versus the look-back measurement period, because that also applies in some of the other changes coming up, if there's a change in status. There are two different sets of rules in the Affordable Care Act. There's a limit on the maximum waiting period, and that's under, as I mentioned, the Public Health Service Act 2708. It can't be more than 90 calendar days from the date the employee is hired or is in an eligible classification, like for full-time. And the penalty for violating that applies to all size employers, not just large employers, and that penalty is $100 a day per affected employee. Now, those rules also allow an employer to have an orientation period for up to 1 month. So if it's a bona fide orientation period, that basically gets you to 120 days rather than 90. And that's usually almost the same as the employer shared responsibility rule of the first day of the 4th month. But because some months have 31 days, it could be different by a few days. Then the opposite, not the opposite, but the other rule is under the look-back measurement period. That applies instead of the waiting period. So that you track the hours, and what if the person is full-time in the measurement period, then they're eligible for benefits, or they're full-time as of the first day of the stability period. And so the potential penalties under employer shared responsibility are the ones I went through before that were originally the $2,000 and $3,000 penalties, and that's IRC section 4980H. But employers also have to comply with the waiting period maximum. So here's an example. The new hire, Brett, is hired as a variable hour employee in February 2016. The initial measurement period begins March 1st, 2016. The employer has a standard measurement period for all current employees, and that starts December 1st, 2016. And so the employer would also start counting the new employee, Brett's hours, as of December 1st, 2016. And if Brett is eligible, if Brett is full-time during the initial measurement period, then he's eligible for benefits during the initial stability period. And this slide just says the same thing, but it's just in words. We also have an initial and standard calculator that you can use, and I think I'm going to come back to that so I can get to the questions that people are asking on the changes in employment circumstances. So there are two different changes in employment circumstances I'm going to talk about. One is if inevitably employees' hours, these come up for many employers. One is a change in hours or employment status, and the other is if there's a break in service and then the employee is rehired. So if there's a change in hours or employment status, you want to look at whether the employee is being tracked under the look-back or the monthly measurement method, and whether they're in their initial or standard measurement period or in a stability period. And so it's going to depend on where the employee is in the cycle when the change occurs. And then the second area is when there are breaks in service. There are two different types of rules an employer can apply, the 13-week rule or the rule of parity. And that applies for all employees. So here's where we're getting a lot of questions, and I'll go back to those questions. So you're going to look at whether the person changed from part-time, variable hour, or seasonal to full-time, and then the opposite of that, whether they were initially full-time and they changed from full-time to part-time, variable hour, or seasonal. And then you're also going to look at where in the cycle was the person when that change occurred. So this first one is if the employee is in their initial measurement period, so they're a new hire, and they were hired as part-time, variable hour, or seasonal, and now they're changing to full-time. And this is the one I mentioned before, that first question we had. The employer has to offer coverage by the earlier of the first day of the 4th month after the date the employee changes to full-time, or the first day of the associated stability period if the employee was full-time in the initial measurement period or went to full-time. And then also that waiting period rule would apply. So here's an example. The standard stability period is January 1st to December 31st, which is their calendar year plan year. Let's say the standard measurement period was December 1st to November 30th, and the employer uses a waiting period of about 60 days, the first of the second month after the date of hire or eligibility. So if an employee is hired June 1st as a seasonal employee, they're going to be in their initial measurement period, and then the employee works part-time June, July, August, and September, or works full-time as a seasonal employee, and then the employee changes to full-time as of October 1st. So the employer would offer coverage by the earlier of, the first day of the fourth month would be February 1st of 2017, or the first day of the initial stability period, which would not be till July 1st of the next year. So given those rules, it would be February 1st. However, the waiting period rule, the 90-day maximum, would be December 29th of 2016, because you're looking at within 90 calendar days of the date the employee becomes eligible. And if the employer has a waiting period that's the first of the second month after date of hire or date of eligibility, then for October 1st, it'd be November, December, so the normal waiting period would be December 1st. And I actually think for most employers, they're going to use the normal waiting period, because if you just hired somebody off the street on October 1st, you would have to offer that person coverage by December 1st. So if you've had someone who's already been an employee for you and worked part-time or a seasonal employee in June, July, August, and September, and now you've decided, oh, we want to hire them full-time, you probably don't want to treat them any worse than you would treat a newly hired employee. So you're probably going to offer coverage by December 1st in this example. Now, the second category, they're still changing from part-time or variable hour or seasonal to full-time, but they're doing it during the standard measurement period. So they're no longer a new hire. They've already been an employee, and they're changing to from part-time or variable hour to full-time. But again, if you remember, let me go 2 slides up and then come back to that. If you remember this picture showing over 4 years, so if somebody's in their standard stability period, they're also in a measurement period. So if they've been part-time here, and now they're in the stability period and they're part-time, they're also in a measurement period at the same time. So under the employer shared responsibility, the change will not affect the employee's classification as full-time or not full-time for the remainder of the stability period. But again, in practice, the employer is likely to offer benefits earlier. And here we've got, again, the same standard stability period and measurement period and waiting period as my first example, but it's an ongoing part-time employee, not a new part-time employee, who already worked at least one standard measurement period, and then they changed to full-time October 1st. So under the employer shared responsibility rules, the employee is still considered part-time in the current stability period, which would go through December 31st. And you're going to track their hours in the current measurement period, December 1st to November 30th. But the waiting period rules are still going to require that the employer offer coverage by the 90th day after the employee is full-time. And if the employer generally has, again, a waiting period of only 60 days or the first of the second month after the date of the change, they're probably not going to treat an ongoing employee worse than they would treat a new employee that they just hired off the street. So let me go through another change, another example. And this is the opposite situation where the person was full-time, and now they're going from full-time to part-time, or variable hour or seasonal. And now, so that's the opposite situation, but now we're going back to the initial measurement period. So it's a new hire that you hired to be full-time, and now they're changing to variable hour or part-time. Well, the reality is that if you hired someone full-time, the reason it's set to be full-time, you should be tracking their hours monthly. So even if they're in a category where the look-back measurement method would apply. So if you're using the monthly method, you can drop the employee's coverage in the month that they change to part-time. You'll probably realistically do it in the first of the next month. But then you do have to offer them COBRA if they already have coverage, and now you're dropping their coverage. Or if they're not yet on coverage, then you wouldn't have to offer them coverage. You could just go back to counting their hours. But there are some complications, because as I said, generally, if you have a new hire who's full-time, you shouldn't have the issue of being in their look-back measurement method when they go to part-time. But what sometimes happens is you hire someone as full-time, then they go to part-time, then they go back to full-time, or you hire them as part-time and they go to full-time and back to part-time, and it's all during what would be their initial measurement period. And there's not a clear answer on what to do because it's not addressed in the regs. I'm sure maybe it will be in future regs. But again, if you hired someone full-time and you're offering them coverage the 2 months later, and they're still in their initial period where you're counting their hours monthly, and then they go to part-time, you can just switch at that time, and you haven't offered them coverage yet. So you can then count them as being in their initial measurement period, and you can start that as of their date of hire. You don't have to move it forward and start it as of their date that they change to full-time. On the other hand, if it was a new hire who was full-time and they've already been there 4 months, so you've already offered them coverage, they're enrolled in coverage, you're still tracking their hours on the monthly basis at that point. So if they go to part-time, you could terminate their coverage. You can terminate their coverage in the month that they go part-time. You might want to wait until the end of that month and do it as of the next month just to be sure, because in real life you might not know that they actually went to part-time. But if they do change from a full-time to a part-time position and they change as of the first day of the month, you could terminate their coverage as of the first day of that month. And you would have to offer them COBRA because they've already been in your plan. Now we're with the same situation, the next example, the same situation where someone changes from full-time to part-time, variable hours, seasonal, but it's after their initial measurement period. So if they're after their initial measurement period, they could be in their initial stability period, they could be in their standard measurement period, they could be in their standard stability period, or they could be in administrative period. But so let me kind of try to address those different places they could be in the cycle. Again, if they were full-time and then they go to part-time or variable hours seasonal, if they're in their stability period, the employee would continue to have the coverage because they're continued to be considered a full-time employee because they were full-time in the measurement period. But there is a special rule that applies when someone changes from full-time to part-time or basically full-time to part-time, or the others. So the special rule is called the F2 rule. And what it says is, if an employee changes to a different position and goes from full-time to part-time, then the employer can begin to apply the monthly measurement method as of the first day of the 4th calendar month after the change, but only if the employer offered this employee minimum value coverage from at least the first of the 4th month after date of hire and through the end of the month in which the change occurs, and then also during the first 3 full calendar months after the employee changes from full-time to part-time, the employee has to average less than 30 hours a week. Now so that's kind of complicated. The other concern is it's not clear whether this applies even if the employee only changes from full-time to part-time but remains in the same position, or if it only applies if the employee goes to a different position and changes from full-time to part-time. So you may want to take the more conservative approach and only apply it in the first one. So here's an example of this special rule, and I think this is often what people have questions about. The employee was hired to work full-time and was offered coverage, let's say, from the first month after 30 days. And she's enrolled, she's been enrolled for some period of time. Now, in this example, I'm going to say she switches to part-time and to a different position. And the employer said, can we cancel her coverage as of the end of the month in which she went part-time? So let's look at step one. What was her original hire date? In this case, it was April 4th, 2014. She was reasonably expected to be full-time. So she was offered coverage June 1st, 2014, the first of the month after 30 days, and the coverage was at least minimum value. So she's had coverage since June 1st, 2014. Then she went part-time March 12th, 2016. And the employer wants to know, after March 31st, 2016, can we take her off coverage? So step two, the employer needs to look at what was the next standard measurement period after the date of hire. Well, in this example with the plan year, the standard measurement period was December 1st, 2014 to November 30th, 2015. Then there was a 1-month admin period, and then the standard stability period was January 1st, 2016 to December 31st, 2016. So the employee is in a standard stability period at the time that she's changing from full-time to part-time. So then you look at what measurement method is the employee in at the time of change. So we're going to say that the employer is using the look-back measurement method, but because when the employee was first hired, they were using the monthly measurement method until the start of the first standard measurement period. So that was until December 1st, 2014. Excuse me. And then starting December 1st, 2014, the employee's hours were tracked in the standard measurement period. And that was December 1st, 2014 to November 30th, 2015. The employee was full-time, so she's considered full-time for the duration of the associated stability period, and that's 2016. So even though she goes to part-time during this stability period, she would be considered full-time through the end of 2016. However, applying that special rule, the S2 rule, if the employer offered her minimum value coverage from at least the first day of the 4th month through the end of the month the change occurs, which we're saying in this case, yes, the employer did, because the employer started offering her coverage excuse me, June 1st, and if the employee averages less than 30 hours a week for the next 3 full calendar months. So that's for if the employee works part-time May, June, and July of 2016, then the employer can terminate her coverage as of August 1st, 2016. So the answer is no, they can't terminate her coverage as of April 1st, 2016, but they can terminate it as of August 1st, 2016. Okay, so then let me look at hours of leave hours during leave and periods of non-service. If an employee has, actually let me do one other thing, and that's, let me go ahead a few slides and first talk about the hours of students and summer interns. I'm going to go to slide 64 real quickly here and then come back. And part of the reason is since someone asked that question, and also not all employers have employees who have breaks in service and then come back. So for some employers, they might be less interested in that part. So let me go to this question. We'll jump ahead and then I'll come back. One employer asked, do we have to track the hours of students who work full-time as summer interns? And what if we hire people part-time and then full-time? Well, the regs specifically provide that if the students are hired through the federal work-study program or a similar state or other governmental work-study program, then they're not considered employees, so you don't have to track their hours. Also, if they were unpaid, you wouldn't have to track their hours if they're unpaid interns. However, the situation for a lot of employers is they are paid and it's not through a work-study program. So that's not specifically addressed in the law or the regulations. There is an FAQ on the IRS website that specifically says the summer student interns will be treated the same as any regular employees, who are paid and work depending on the hours they work. So there are two different arguments you can make, and I would say you need to talk with your legal counsel. One of them is the summer intern does not meet the definition of a seasonal employee because interns could be hired anytime during the year and they're going to perform the same type of work. So if that's the case, then you have to treat the summer intern who works 40 hours the same as a regular full-time employee and track their hours monthly. That doesn't necessarily mean you have to offer them coverage, because if you go by the employer shared responsibility rule and you don't offer coverage until the first day of the fourth month, if you only hire them to be full-time interns during the summer for 3 months, then they're not employed anymore as of the fourth month. The opposite argument is summer interns are seasonal employees, especially if you don't hire them except in the summer, because the summer internship can only be performed while the student is out of school in the summer. And so then you could track them over the measurement period, and then you would have a 12-month or a 6-month measurement period. If you're going to take that second approach, again, talk with your legal counsel, because the first approach is the more conservative approach. So if you're going to say that summer interns are seasonal employees, then you probably want to classify them as two separate positions. If you hire student interns full-time in the summer and part-time the rest of the year, you want to have them change employment positions when they go after the summer internship. So a couple other thoughts is, even if they're considered to be regular full-time employees, the employer might want to exclude them from eligibility, even if they work full-time. And again, one of the reasons is that 4980HA penalty only applies if you're a large employer and you don't offer coverage to at least 95% of your full-time employees. So if your student interns are 1% of your full-time employees, your policy could be that full-time student interns or summer interns are not eligible for benefits. And then you would not have the 4980HA penalty. But you could still have the 4980HB penalty. So if a summer intern worked full-time for the summer and then you also hired them part-time, and then you didn't offer them benefits because they're the 1% of full-time employees that you're not offering benefits to, you might end up with a B penalty if that person went to the subsidy and went to the exchange and qualified for a subsidy. However, a student is likely to have coverage available through their parents' plan through employment. That might not always be the case. The parent might not have a plan through employment, or it might be available but the employer doesn't pay anything toward it, or maybe the parent just feels that the employee is a college student and they're working and they should pay for their own coverage. The other thing is, as I mentioned earlier, when there's a change in status, if you hired them in a full-time position but they changed to part-time before they were actually offered coverage, then I think arguably you could revert to tracking their hours during that initial measurement period. And then they would be part-time, if you had not already offered them coverage, and you could track their hours, say they're hired June 1st, you could have the initial measurement period starting June 1st, and you could go back to tracking their hours over that measurement period. Okay, so let me go back up then, since we had that question. Let me go back up to a few pages. Sorry for switching back and forth here. I'll talk about the breaks in service. Again, some employers might feel that they don't really have to deal with this if they don't have employees who have a break in service and then come back. So the reason this matters, the break in service policy, is it's going to determine whether the person who has a break and is rehired is an ongoing employee or a new employee. If they're an ongoing employee, then when they return, there's no new initial measurement period. They just go back to where they were in the cycle, and you count all their hours of service during that measurement period before and after the break. On the other hand, if the rehired person is considered a new employee, then they do have a new initial measurement period, and you don't count the hours that they worked before the break. You just start counting the new hours. And again, keep in mind what I said before, the hours that do count, the hours worked, the hours on paid leave, the hours during special unpaid leave. And one question I've had here is, what about overtime hours? If somebody's paid time and a half or double time, does that count as 1.5 or 2 hours? And the answer is no. An overtime hour only counts as 1 hour, even if the person is paid time and a half or double time. So an employer needs to have a policy, and we have a sample measurement method policy that employers can get from your Leavitt advisor. And there's 2 different rules that an employer could adopt, the 13-week rule or the rule of parity. So the 13-week rule is the easiest to apply, but it's more generous. And it says if an employee has a break, either they're terminated and rehired, or they're not terminated, they just don't have any hours of service, for less than 13 weeks, then when the employee returns, you have to treat them as an ongoing employee. So you're counting hours before and after the break. And if an employee has no hours of service for 13 weeks or more, then when the employee returns or is rehired, you have to treat the employee as a new employee. So that means they have a new initial measurement period. And this just shows the same thing I just said, but sometimes it helps to have it in a 2-column version so you can, and 2 colors, so you can see what the differences are. The other rule is the rule of parity. If an employee has no hours of service for less than 4 weeks, then when they return, you treat them as a continuing employee or ongoing employee. And this rule, as you can see, is a little more complicated than the rule of parity, but it's also less generous, but it's more difficult to administer. And if an employee has no hours of service for 13 weeks or more, then when the employee returns to work, they're treated as a new employee, so they have a new initial measurement period. And if it's between 4 and 13 weeks, then you compare the length of the leave time to the length of the prior employment time. And if they are on leave for longer than their prior employment time, then they're a new hire. And if they are on leave for less than their prior employment time, then they're an ongoing employee, and you count the hours before the break. And again, this just shows the same thing I just said, but it's in the 2 columns and 3 different colors, and sometimes that helps in making it clearer. But I think the examples are often the most helpful. So here's 2 simple examples. The rule of parity: an employee works for 5 weeks, let's say in January and a week in February, and then they have no work for 7 weeks, so the rest of February and all of March, and then they're rehired or they return to work. And in my example, the employer has a 6-month measurement period because it fits on the slide better. So when the employee returns to work, you can treat the employee as a new employee, so because they were gone for longer, they were there. So you don't count the hours worked in January, and then starting April 1st, the employee has a new initial measurement period. And that would be April, May, June, July, August, September. The second example, no surprise, it's the opposite. So the employee works 3 months, January, February, March, and then they terminate or they have no hours in April and May, and they're back as of June 1st. And when the employee returns, you treat this employee as an ongoing employee because they worked there longer than they were gone. So the hours that were worked before the break have to be counted in determining if the employee was full-time or part-time. So the hours on leave still count as 0, but unless it's a special unpaid leave, and then they would count. But for a 6-month measurement period, if the employee worked at least 780 hours in January, February, March, and June, then they would be considered full-time, and they have to be treated as full-time in the associated stability period. And then here's a little more complicated example where we're looking at the full year, and the employee works 2 months, then they're gone for 1 month, then they work 3 months. And in my simple example here, there's no administrative period. So the stability period just starts July 1st so that it fits on the slide better. So if the employee worked at least 780 hours in January, February, April, May, and June, then they would be offered benefits as of July 1st. So they enroll in benefits, but then if they're gone in August and September and they didn't have benefits, and then they return October 1st, the employer has to offer, they're in their stability period, so they go right back into the cycle where they were, and the employer has to treat them as an ongoing employee, and they would be offered benefits as soon as possible, and the regs say it can be no later than the first day of the next month. So then in this case, the employee would be offered benefits actually October 1st, and then have benefits or the rest of the year. So here's back to the question on the summer interns, and then I had one more set of specific questions, and then I'm at the end. So let me see if there are other questions. Let me go through these, and then I'll see if there are other questions, because this might answer some of the other questions. In this case, an employer hired a full-time and a part-time employee on March 14th, 2016. They have a 12-month measurement and stability period, a 1-month admin period, and the same as I used before. The stability period is January 1st. When should we start the look-back period? For the full-time employee, you're using a monthly measurement method, so you start on the date of hire. There's not really a look-back period. It's just a monthly measurement period. However, keep in mind that the look-back period still starts on the date of hire or the first of the next month, just in case the employee later changes to part-time. If you have a part-time employee, then you can start the measurement period either on the date of hire, March 14th, or on the first of the next month, which would be April 1st. The employer's next question was, when would the look-back period end? Well, for the part-time employee, the initial look-back measurement period ends 12 months after it starts, since it's a 12-month period they're using. So that would be either March 13th, 2017 or March 31st, 2017 if you used April 1st as the start date. For the full-time employee, if you're using a monthly measurement method, that starts on the date of hire, so there's not really a look-back period that applies unless the employee changes to part-time. And here's just the graphic depiction of it in case that helps. More specific questions, the same two employees, a full-time and a part-time employee hired March 14th. When does the next look-back period start for these two employees? Well, again, there's only one initial look-back period. So for both employees, the next look-back period is the standard look-back measurement period, and that begins December 1st, 2016. And then the next question is, when does the employee cease to be a new hire? And again, the general answer for both of them is that a new hire becomes an ongoing employee as of the end of the first standard measurement period that began after the date of hire. So that first standard measurement period begins December 1st, 2016, and ends November 30th, 2017. So both the full-time and the part-time employee become ongoing employees as of December 1st, 2017. And let me just go back to this picture, because maybe that kind of helps. That during they're hired March 14th. The first standard measurement period after their date of hire is December 1st, 2016. But the part-time and the full-time employee, new hires, become ongoing employees as of the end of the first standard measurement period. So they become ongoing employees as of December 1st, 2017, even though they were hired March of 2016. And just a note, sorry, they keep cutting the grass right outside my window. If you're going to determine if the new full-time employee will be eligible as of January 1st, 2018, which is going to be their first standard stability period, you're going to look at how many hours they worked over that first standard measurement period. So that was the December 1st, 2016 through November 30th, 2017. So more specific questions, still the same situation, the full-time and the part-time employee hired on March 14th, 2016. How many hours do they have to work to be eligible as full-time? And again, the 12-month measurement period is 1,560 hours. For the 6 months, if you had a 6-month period, it would be 780. If the employee works 1,560 hours by the end of the 10th month, should we offer coverage as of the first of the next month? The answer is no, you're not required to offer coverage right away as soon as the employee works 1,560 hours. You can wait until the first day of the associated stability period, even if the employee reaches the 1,560 hours before the end of the measurement period. And this employer also asked, they sent a whole lot of questions with the same scenario. When should the employer run the payroll reports to count the hours, how many hours someone worked during the look-back period? Well, the employer, I think, is going to run the report monthly, and you're going to probably request the monthly reports from your payroll system, and the monthly report should flag employees who are on track to have the 780 or the 1,560 hours during the measurement period. So if you're 6 months along in it or 10 months along in it, it'll extrapolate from the hours to date. Those hours could change, but it's probably going to red flag those people who are on track to be full-time. And so you'd probably have in that report the information on everyone. It would probably also show new hires who are in their initial measurement period, how far along they are in their initial measurement period, which is probably going to be a separate 12-month period for each of them, and who's on track to be full-time by the end of their initial measurement period. Now the next question is, what if as of August 1st, the part-time employee changes to full-time? When should the employer offer coverage? Is it 30 days from the status change date? And in this case, their waiting period is 30 days. So again, I know we've gone through this same kind of example several times, but it's a question that's coming up a lot. The person is part-time, they're still in their initial measurement period. So when they change to full-time, the employer has to offer coverage by the earlier of the first day of the 4th month after the date the employee changes to full-time, so that would be December 1st, or the first day of the associated stability period if the employee was full-time in the initial measurement period. So then you're going to look at their hours, and that would be May 1st. So right now you're looking at December 1st, but then the waiting period rule is also going to apply. The 90-day limit would require coverage by October 29th if the person changes to full-time on August 1st, because then 90 days would be September, October, November, but it's going to be not quite November because some days have 31 days. Some months have 31 days. But if the employer has a 30-day waiting period, then from August 1st to September 1st, they could apply the 30-day waiting period and offer coverage September 1st. And again, I think a lot of employers will want to apply their regular waiting period, because if you just hired someone new on August 1st, if you had a 30-day waiting period, you would be offering the new hire benefits as of September 1st. So you probably don't want to treat an ongoing employee who now you're moving up from part-time to full-time. You probably don't want to treat them worse than somebody that you've just hired who never worked there. So still looking at the part-time employee changing to full-time, what's the anniversary date of the look-back period? Well, the initial look-back period still stays the same, but it doesn't matter if the employee changes to full-time and stays full-time. But if the employee changes to full-time and then changes back to part-time within the initial measurement period, then you could drop their coverage when they change back to part-time and track their hours during that initial measurement period, which would start on their date of hire or the first of the month after that. And then you could track their hours during their full-time and part-time hours during that measurement period. But if they were on coverage and you drop them, you still have to offer them COBRA. And then the next question was, how does it affect the stability period if the employee changes from part-time to full-time or from full-time to part-time? Well, the answer is it doesn't. The initial stability period remains the same if it applies, if they're not in the monthly method, and that initial stability period only applies once. And then if the employee is there through the standard measurement period, they're an ongoing employee, so then the standard measurement and the standard stability periods apply. So they fall into that standard stability period. And some more specific questions, same employees, what if it's the full-time employee who was hired March 14th and changes to part-time August 1st, so the opposite of the first way? And what if they're no longer working enough hours to support the payroll deduction? Who pays the premium? Well, first of all, it could be that they're if you're going to track their hours on a monthly basis, if the employee was enrolled in benefits, you could drop the employee's coverage once their monthly hours are less than 30, because if they are hired to be full-time, they're not in a look-back measurement period, they were in a monthly measurement period. So you've probably already offered them benefits, so then one thing is look at what your measurement method policy says. It might say in the month they change to part-time, you drop their coverage, or it might say in the month that the first of the month after they change to part-time. That special rule is not going to apply if the person was just hired in March of 2016 and changes to part-time in August of the same year. So that special rule where we went through the complicated example will not apply. But look at what your measurement method policy says. Again, if you don't have one, talk with your Leavitt advisor and have them help you determine what you want your policy to be. Now, the practical advice, if the employee was a full-time employee, has been offered coverage and is already enrolled, and then changes to part-time, you might want to wait until the month after the change, because you won't really know until the end of the month that they actually worked part-time. So just to be on the safe side, you might have in your policy that you wait until the first of the next month. And if an employee goes from full-time to part-time, how long does the employer have to offer coverage after the change in status? And again, it depends on where the employee was in their measurement cycle. So if they were full-time through the measurement period and now they're in their admin period, even though they changed to part-time, the employer would still have to offer coverage, because the hours of service in the measurement period determine whether they're eligible in the stability period. So the last thing, we got through all those examples. The last thing is be sure to document your measurement methods and your periods. So have a separate written policy, add some language to your handbook, even if it's general language, and you refer to the separate policy. Have language in your SPD, your enrollment materials, your plan document. And part of that, you'll need to define variable hour and seasonal employees and who's eligible and ineligible for benefits. Again, we do have a sample measurement method policy It looks very long, but once you delete the sections that don't apply, it's much shorter. It turns into a much shorter policy. You can talk to your Leavitt advisor and on getting a copy of that sample or template measurement method policy. Here's a link to guidance that are in the final regs. The final rule on the employer shared responsibility was 227 pages. There is an IRS fact sheet that's three pages, and the IRS questions and answers online, which are very helpful. And I did just check those links 2 days ago. And here are links to several Leavitt articles that you might want to look at with these kinds of questions. One's on seasonal employees, larger employers applying the same measurement method to all employees, and using the Lookback measurement method to determine full-time status. So let me, first of all, thank you all for your attention and for hanging in there. And then let me see what other questions we have of, looks like some more questions have come in. So if an employee quits during the stability period, do we continue to offer coverage or do we offer COBRA? Well, again, if they're in their stability period, generally, if they were full-time in their measurement period, they're considered full-time through the end of the stability period. So the answer is yes, you'd have to continue to consider them full-time, which probably means you're going to continue to offer them benefits. If you don't continue to offer them benefits, or if you now pay less toward it, which would be considered cessation of benefits for COBRA purposes, then you will have to offer COBRA if they've been on coverage. And again, there also is that special F2 rule that applies, but you need to go through all those steps. So you could go back to those slides and go through the steps that if the employee has been there for a while and there's a change in employment status, then you may be able to stop offering coverage if they're part-time for 3 months. And actually, if they quit during the stability period, sorry, I kind of went off on that tangent. If the employee quits during the stability period, you do not have to continue offering coverage. It's only if, excuse me, they changed employment status and went from full-time to part-time. So if the employee quits during the stability period, you do not have to continue to offer coverage, but you do have to offer COBRA. Other questions people have is, this webinar is recorded, and we will have the presentation available. It will probably be in the next day or two. We get it downloaded and recorded. It's an MP4 file, and we'll post that, and then we also make it into a YouTube video so you can watch it on YouTube. So part of it should be, the MP4 should be available this afternoon, and the YouTube probably by tomorrow afternoon. Another question, as a school district, some employees do not work for 2.5 months in the summer, 2 weeks at Christmas. How do we count those months? And I'm sorry, I did not go into that special rule. There's a special rule for educational institutions that if people aren't working because the institution is closed down, you basically have to count those, either not count those months in your measurement period. So for example, if it's 2 months, your measurement period is 10 months instead of 2 months, and is 10 months instead of 12 months, and you count the hours that they worked during those 10 months. Or the other way of doing it, which gets you to the same result, is your measurement period is still 12 months, but for the 2 months employees didn't work, you attribute hours of service to them that are the same as the average number of hours they worked in the other 10 months. So, and if you'll contact me after the webinar or contact your Leavitt advisor, we can send you some information on that. But there is a special rule for educational institutions. Let's see. In terms of how to access it, how to access the videos, the GoToWebinar should send out an email to everyone who attended afterward, like tomorrow, and we'll include the link in there. Another question, what if the employer does not have a measurement period because they only hire full-time employees? Can they terminate the employee at the end of the month because they're no longer full-time? Well, the employer could apply the monthly measurement method to all employees, and if they only hire full-time employees, then they would be counting the hours per month for all employees, and they could terminate coverage at the end of the month because they're no longer full-time. So, but the employer should have a measurement method policy that says we only apply the monthly measurement method. But then if you do hire people who have variable hours or go in and out of coverage, you're going to have people coming on and going off at, maybe at the end of each month. But yes, if you only have a monthly measurement method and not a look-back measurement method, then you'd be just looking at that month. Next question, we have a variable hour employee in an ongoing stability period with coverage. She changed to full-time with a different company group who has a different medical plan. Of course. Does she remain on the previous coverage during the full-time waiting period? I would say the answer is yes. And the waiting period is the first of the month following 60 days. So yes, the employee remains eligible if they were a variable hour employee, was full-time in their measurement period, and now they're in a stability period with coverage. The person could continue on that coverage until the end of the waiting period. I mean, they could do that on COBRA, or since they're an employee with the same, sounds like the same control group, the same company, I think she would continue as an employee for the duration of the waiting period until she's eligible for the other medical plan under the other company in the group. Next question, are you able to end coverage during a leave of absence for full-time employees if they take an unpaid, non-special leave of absence in their stability period? The answer to that is yes. You can end coverage for someone who's on an unpaid, non-special leave of absence, but then if they come back within the 4 weeks or the less than 13 weeks, or depending on which rule you're using, you'd have to consider them an ongoing employee and put them back in where they were in the cycle and basically offer coverage by the first day of the next month after they return. And then the college students, and then that's it. So let me see if any other questions have come in at the end. Okay, that's it. Thank you for your attention. And we did run over on the time here. I apologize, but there will be recordings available, MP4 recording, and then also a YouTube video. So again, if you're really a glutton for punishment, you can, or if you had to leave, you're welcome. You can listen to it again, and the system should send out the link to it, and if it doesn't, please contact your Leavitt advisor and they will send you a copy of it, because we'll post it internally and it should be accessible externally as well. So again, thank you all for attending using the look-back measurement method, and I hope you found it helpful.